Now then, it's 7:28. Thank you for watching us here on Breakfast. Two brothers who deny assaulting a police officer at Manchester Airport in 2024 will not face a third trial. This after two previous juries have failed to reach a verdict.
So, this footage of a brawl was widely shared across social media. This was 2 years ago. An earlier trial found one of the brothers guilty of assaulting two female officers and a member of the public.
Well, Let's speak now to criminal lawyer Joseph Kotrie-Monson. Good morning to you. Thank you for coming in. I mean, this really is a case which has sparked such public interest, largely because of what was published on social media. That's kind of changed the way people think about the case and how much people know about the case.
Absolutely. Wasn't it a game of two halves in that regard? Two very different types of video showing a very different perspective on an incident at different stages. I think many people who saw one video took one view, many who saw the other took the other view. Isn't it important, Sarah, that we allow juries to make the decisions about people's guilt after a carefully managed and husbanded process? Of course, there were a lot of comments in social media, and the judge was was more than a little concerned with regard to those comments. There were defence applications, but both trials went ahead in the end without a hitch.
Maybe just take us through the legal process, because it is really complicated, I think, to get your head around, isn't it? You know, as journalists, we've sat in courts, we've kind of watched court cases going on. Lawyers, you know about it. But in terms of retrials, just take us through the process in this case and what we've gone through and where and why we are where we are now.
Well, the general principle, Sarah, is that in the first instance, a jury must come to a conclusion unanimously. If after an appropriate amount of time they can't make a decision, the judge can direct them to a majority. That means 10-2. In some cases where the evidence is finely balanced, the issues are live and contested, and a conclusion to that standard or that level of majority can't be reached by the jury, that's a hung jury. And the prosecution have the opportunity of a second bite. They will often take that if the evidence has gone in a way that they feel they might have won it the first time around. So, for example, on the one hand, you may remember the case of Benjamin Mendy. There was a retrial. After a hung jury and, in fact, an acquittal the second time around. Ryan Giggs, however, in his domestic assault trial, ultimately hung jury. Prosecution didn't have an appetite for it a second time around. Retrials are expensive. In the first place, the type of case that might be considered for retrial is already likely to be high profile and serious. And in circumstances where the prosecution can see, well, we failed once, what's different that we might succeed again, especially when it's high profile and there may be some career motivations at play. They're humans, after all. You can see why they might not have the appetite. In this case, there is a consideration whether after losing a case or having a hung jury, more accurately, on two occasions, a prosecution does have the option of going for a third time. But that's something that they are much less likely to want to do. And in fact, there is CPS guidance which suggests that they really shouldn't, unless, in the words of the Court of Appeal, on the one hand, the offence alleged is one of extreme gravity. This was ABH, actual bodily harm, a mid-level assault. Clearly, probably doesn't pass that test. And also that objectively there is a strength to the evidence that means that the prosecution really in good conscience must proceed again. This was a case where an active defence was put. We've just talked about the fact that there were very different sides to that incident, in which a police officer, as part of the defence case, was himself alleged to have committed an assault. The juries clearly had difficulty with that on two occasions. The idea of a third bite, not just compounding the difficulties, compounding the failure of the prosecution, I think it was just too rich for them.
Joseph, I mean, it's interesting hearing the sort of mechanisms working within. How much of an issue, increasingly, is it that images have already been seen before a trial starts? So, in a way, and I think you alluded to this in your first answer, that the public has the possibility of kind of coming up with their own verdict way ahead of the trial. And that must be something that's happening more and more in the court process.
Well, they say that where as regards opinions, everyone's got one. And, in fact, having an opinion isn't necessarily a problem. We, of course, live in an age where phones come out at the point of anything exciting or controversial. In a way, that's a good thing. It holds police to account. It holds us all to account on public transport and whatever else. But where there is a risk of a jury seeing a prejudicial comment, seeing evidence that's presented in a certain way and being swayed on it, especially
if it's gone viral on social media, for example, the chances go up and up, don't they?
It goes viral, and something that is interesting, where it's especially important, because the fact that it's interesting is also has something in common with the fact that it's serious. It's especially important that kind of stuff is treated with extreme caution, because you see clips. We know that with deep fake stuff, you can manipulate video images. You don't need to do that if you present something in a certain way. And presenting snippets that don't show the whole of an incident, if there's a possibility that thing that you post, that comment that you post, can be tweeted 200 or 300 times, seen 7,000 or 8,000 times, seen by one influential jury member, and all of a sudden, without realising it, even though you might have tweeted it because you want to exercise your right to talk about the fact that you want justice in that situation, you may end up influencing and actually preventing the right of not just defendants but victims to get access to that just and fair process with your time on your keyboard.
It's really interesting. Joseph, thank you very much. Joseph Kotrie-Monson is a criminal defence lawyer. Thank you very much for your expertise this morning.